attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a Lawcast series talking about the differences between a smaller reporting company and an emerging growth company. The topic of reporting requirements and distinctions between various categories of reporting companies has been prevalent over the past couple of years as regulators and industry insiders examine changes to the reporting requirements for all companies and qualifications for the various categories of scaled disclosure requirements. As I've written about these developments, I have noticed inconsistencies in the treatment of smaller reporting companies and emerging growth companies, many of which appear to be the result of poor drafting or unintended consequences. As a reminder, a smaller reporting company is currently defined as a company that has a public float of less than $75 million in common equity as of the last business day of its most recently completed second fiscal quarter, or if a public float of zero has less than $50 million in annual revenues as of its most recently completed fiscal year end. On June 27, 2016, the SEC issued a proposed rule to change that definition. The SEC proposes to amend the definition of a smaller reporting company to include companies with less than a $250 million public float as compared to the $75 million threshold in the current definition. In addition, if a company does not have an ascertainable public float, a smaller reporting company would be one with less than $100 million in annual revenues as compared to the current threshold of less than $50 million. An emerging growth company, or EGC, is defined as a company with total annual gross revenues of less than $1 billion during its most recently completed fiscal year that first sells equities in a registered offering after December 8, 2011. An EGC loses its EGC status on the earlier of the last day of the fiscal year in which it exceeds $1 billion in revenues, the last day of the fiscal year following the fifth year after its IPO. For example, if the company has a December 31 fiscal year end and sells equity securities pursuant to an effective registration statement on May 2nd, 2016, it will cease to be an EGC on December 31, 2021. Third, the date on which it has issued more than $1 billion in non-convertible debt during the prior 3-year period, or the date it becomes a large accelerated filer, i.e. its non-affiliated public float is valued at $700 million or more. EGC status is not available to asset-backed securities issuers reporting under Regulation AB or investment companies registered under the Investment Company Act of 1940. However, it is available to business development companies. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.